today also, not just the time, but also the topic is also slightly unusual in our past meetings, because today we invited experts from different firms, from the Minter Allison from Australia, from excuse me, Davis from Canada, and the Zhonglen Law Firm from China, and we will talk about today an issue very frequently linked to antitrust reviews for investments, but as I said, closely related but not same. It's the foreign direct investment reviews in different regimes. And as I mentioned, we have Melissa from Minter Allison, who are talking about mostly the investments in Australia, and also Rachel Lee talking about FDI in China, and also Mark, he will give us a presentation about those regulations on foreign investments in Canada. So as we scheduled, we will let Minter Allison, Melissa Lai to start with the introduction of legal regimes in Australia. So everyone, let's welcome. Yeah, Melissa. Thank you.
Thank you. Thank you, Scott. Hannah, is it okay if I share my screen? Is that the easiest way to do that?
Yes, you can go ahead and do that via the button at the bottom.
Great. Mark, I know you said I didn't need a slide deck, but hopefully you can all see the PowerPoint there.
We can see all of the slides. It's not in presenter mode. There we go.
If I do, fantastic. So I'm conscious of time as well, so I will keep this relatively brief, and I understand we didn't really need a slide deck and this is more of an informal chat, so please feel free to ask me any questions you have along the way. But just to set the scene, I suppose, Australia's had a foreign direct investment regime for, well, since 1975. And it's a pretty broad-ranging regime that captures quite a lot. So a lot of people are considered foreign for Australian purposes. Even, say, certain Australian individuals who have family trusts that don't exclude foreign beneficiaries. Those foreign beneficiaries in discretionary trusts are deemed to hold 100% of those trusts. And so you could have Australian citizens ending up as foreign people under our rules, just to give you a sense of how broad that is. Once someone's foreign and they're captured by the rules, it then applies to a very broad range of investments. And what that combines to get is a set of rules in Australia where most things are captured, most things are screened, and then the vast majority are permitted on the basis that it is not contrary to Australia's national interest. In the course of considering that, our Treasurer, the Treasurer of Australia, makes these decisions, can decide to approve something conditionally, so decide that certain conditions need to be imposed in order for a transaction to be considered not contrary to Australia's national interest. Or can choose to approve a transaction unconditionally. And over the last 7 years or so, we've seen a significant set of reforms in the Australian rules, a focus on critical infrastructure investments, and with COVID, particular changes that occurred in 2020, meaning, you know, a number of transactions that fell below certain monetary values. They used to have exemptions, but during COVID, those exemptions were removed. So there was a $0 screening threshold. That's come away now, now that we've returned a little bit back to normal. But after those $0 thresholds were lifted, we had a significant round of national security related reforms. So it's a constantly changing landscape in Australia in terms of what gets captured under the rules. I said that, you know, a significant majority of transactions ultimately get approved. And prior to COVID, I would have said that, you know, in the 2 decades prior to that, there were probably only a handful of transactions that were publicly blocked. These you might have, heard in the headlines over the years, things like certain foreign investors being blocked from acquiring Ausgrid, the New South Wales electricity network, on the basis that there were national security issues associated with that, as well as, certain investors being blocked from acquiring Kidman Cattle, which accounted for something like 3% of Australia's landmass, farming landmass, and we ultimately helped the successful bidder in that process, which was a consortium between an Australian investor and a Chinese investor to make that acquisition successfully after 3 rounds of different consortium mixes. And prior to that, ADM Grain Corp was blocked, Shell, Woodside, and there really weren't that many, but with the changing focus on national security, and particularly with the introduction of rules around critical infrastructure as a result of looking at supply chains during COVID, I would say that there has been a significant increase in scrutiny that's applied to transactions, and an uptick in applications that are withdrawn because it's unlikely that they would get the relevant approval. So that's just to set the scene. As Scott said, foreign direct investment rules, they don't necessarily sit in antitrust, but they regularly deal with antitrust issues as well. And I'll touch on that a little bit later on in my comments. And I guess I'll also touch on sort of what the compliance landscape looks like and what the trends are at the moment. So just moving briefly to this idea of who is a foreign person, why is it so broad? There are certain tracing rules that apply that mean that, in this diagram, this Australian entity at the bottom is still considered to be a foreign person, even though at the 2 levels above, you've got 80% Australian co-investments, and this Australian entity is effectively controlled by Australians. But the effect of the rules, one of the many rules, is that if you've got a foreign investment entity that has 20% of the Australian entity, that Australian entity is deemed to be foreign. And in this example, you can see that the foreign person holds 20% of the investment entity that then holds 20% of the Australian entity. The rules don't have any sort of dilution effect there. So even though this foreign person only has 4% economic interest in the Australian entity, so that's 20% of 20%, the tracing provisions mean that the Australian entity is still foreign, because the foreign person right at the top, their 20% interest continues tracking through. And that's just an issue that means that many more people than you would think get caught in our foreign government investor rules. So foreign government investors can be state-owned enterprises and sovereign wealth funds, the people that you typically think of as foreign government investors. But it also captures a vast range of private equity funds that look to raise capital from places like state pension funds or other public pension funds looking to ensure a return for their investors. And the significance of that is that foreign government investors under Australia's rules get very, very, very few exemptions. So they need to seek FIRB approval through the Foreign Investment Review Board for nearly everything that they do in Australia, whereas private foreign persons get the benefit of certain investment thresholds. That mean that if an investment is below those thresholds, they do not need to seek approval on a mandatory basis. So just to give you a brief sense of what those thresholds look like, there are acquisition thresholds, and then there are also monetary thresholds. So just to start with these acquisition thresholds, you can see that, the sort of regular M&A transactions typically have a 20% threshold for private foreign persons. But then there are a range of other sensitive investments in Australia that get carved out. And if you've got an M&A transaction that falls into one of these other categories, it's a media business, or it holds certain interests in land, or it's a national security business, or in the agribusiness sector, then that acquisition threshold drops from 20% down to a lower number. And if you've got a foreign government investor involved, then that also drops down. I guess what I'll touch on here is that a little bit about the process of getting the approvals. So the approval goes through the Australian Foreign Investment Review Board screening process. As I mentioned earlier, the Treasurer of Australia is the ultimate decision maker. And in the course of that being screened through the Foreign Investment Review Board, many government agencies will be consulted. And one of the government agencies that will always be consulted is the ACCC to consider the transaction from an antitrust perspective. And the reason for that is in determining whether or not something is or is not contrary to Australia's national interest, there are 5 factors the Treasurer takes into account. And they are, one of them, national security, the second of them, impact on competition in Australia. The third is impact on the Australian economy and community. Another one is looking at compliance with laws, so including tax policy and tax law. And the final factor is looking at the character of the investor. But because of the link to the ACCC, what we end up having in Australia is sort of a de facto mandatory antitrust filing if FIRB approval is required for a transaction. So even if a transaction otherwise doesn't raise any concerns around substantially lessening competition, where someone is doing a deal that needs to go through the FIRB process, we generally recommend that an antitrust filing in one form or another is made as well to help to smooth that process through. That might change a little bit if Australia goes ahead with having a mandatory antitrust filing set of rules, which I understand Mark, my colleague Miranda, will perhaps touch on at the next one of these meetings, but just wanted to flag that up front now. I also mentioned that one of the factors in looking at the national interest test is the character of the investor. And I guess relevant to compliance with laws and the character of the investor in the current environment is that we've seen a real increase in transactions where there's a focus on compliance with laws overseas for investors, foreign investors looking to continue investment in Australia or to invest here for the first time. So compliance with things like sanctions laws, export control laws, anti-bribery and corruption, all of those things go to the character of the investor. And so one of the trends we've seen is that might lead to significant additional conditions imposed on an approval if there have been any compliance issues outside of Australia when an investor is looking to come into Australia. And I've mentioned the phrase national security quite a bit. We reformed the rules in 2021 to pick up certain businesses as national security businesses, which have a $0 threshold. So prior to these rules coming into place, a private foreign person could acquire a data center that had, significant sensitive government information without getting any approvals because it would have fallen below the monetary threshold and there weren't foreign government investors. That was a little bit of a gap and the government's put in changes to try to close that gap. One of the other gaps from sort of 2015-16 that you will no doubt also have seen in the headlines is the lease of the Port of Darwin to a Chinese-based group back in 2015, which was a lease from government at the time and was fully exempt from the rules. That's caused all sorts of different controversies and headlines in Australia, but the rules around acquisitions from government were changed in 2016 to ensure that wherever there is an acquisition from government and it includes critical infrastructure, no exemption exists. The changes in 2021 around national security was to sort of broaden that set of rules so that anything that is a critical supply into the defence sector involves security classified information, involves defence personnel information, involves our telecommunications sector, all of those things, you know, all of those types of assets would be subject to the $0 screening threshold. And then as recently as December last year, that idea of national security business had a much more expanded list of investment types that would be caught as national security businesses. The reason for that is the idea of critical infrastructure. So critical infrastructure used to be sort of what you would typically think of as critical infrastructure, you know, water, electricity, pipelines, ports, airports, that sort of thing. It now encompasses those things you see on screen. So, you know, for example, our food and grocery sector, financial services and markets, higher education, and those sorts of things that probably don't naturally come immediately as, you know, a critical infrastructure asset to the minds of most people, but have now been included in this list. And that linkage means that it is a national security business for purposes. And so any investments in these sectors also need to be considered quite carefully. In terms of trends that we're seeing, as I mentioned, at national security, so we're seeing a lot more of different types of transactions being caught, a lot more in terms of timing for applicants going through the process. An acknowledgement that, you know, in any investment, you've got to think about what is the national interest focus here, and are there any sensitivities in a transaction that mean that the commercial factors for that transaction, you know, don't sort of outweigh those national security factors. And so as a result of that mix of issues at play, we've seen an increase in potential rejections. And so applicants then choose to withdraw their application rather than having a published rejection of their application. And then I guess that I just wanted to touch on compliance as well. So in 2015 and in 2021, the regulator received 2 boosts to their ability to enforce these rules. In particular, infringement notices. So the idea that the regulator can issue administrative penalties instead of pursuing something in court, it is now in play under the Australian Foreign Investment Rules. So in combination with the very broad set of transactions that might be captured, the fact that if something is captured on a mandatory basis, it is a criminal offence not to seek the relevant approval. It's something that you cannot close over, and that there are these increased abilities for the regulator to issue penalties, points to sort of an environment where this is taken very seriously by the Australian government. And it's just a sort of ever evolving area. Conscious I've spoken for a bit there, so I might stop and see if there were any questions before we moved on to the next speaker.
Melissa, I had a question. It's Mark. Are all the national security decisions, are there published decisions?
So the decisions are not published. Only decisions that end up being published are orders to block, or where there's significant sensitivity and the Treasurer chooses to make an announcement about the conditions that he or she has imposed. So one of those investments I am thinking of there is I can't remember the year now, but a few years back, an investor acquired a dairy farm in Tasmania, and that was approved on various conditions, and announced that that was not contrary to Australia's national interest because of those conditions that were imposed. And subsequently, there have been allegations that those conditions haven't been complied with, and that's sort of been one of the factors that has led to the regulator getting more powers to issue infringement notices and things like that.
Okay, thank you.
I'm very surprised about the broad definition of foreign persons. Have there been any problems if a 20% shareholder of a 20% investor then holds shares in an Australian company, and this company then acquires it? And second, this must lead to a lot of cases covered. And the second question, how many transactions are under review under these rules in Australia?
Yeah, so there's quite a significant number of transactions under review for that, exactly that point that you raised, Harold. So I would say that it is, in my experience, highly unlikely that a 20% of a 20% investor ends up, having problems through the process. Rather, that definition is there to sort of set the screening boundaries. So the idea, again, is that a vast majority of transactions are captured for screening, so that the Treasurer can make a decision that it is not contrary to Australia's national interest. And one of the points there is that, having this screening regime gives the Australian public confidence in foreign investment being screened, and so is a way of boosting Australia's, appetite for foreign investment, and sort of that general policy that Australia is open for business. It's just kind of in this world where the regime has been set up from the beginning to screen quite broadly. Probably see over, probably 1,500 to 2,000 what I'll call M&A transactions in a year. There is a significantly higher number of land and other, residential type applications that get processed by the tax office. I mean, the foreign investment rules in Australia were really set up right at the beginning to be concerned around specific investment types, and there's been a big focus on land acquisition and land banking in Australia. So there's a big focus on those types of rules as well.
And there's a strong link between the ACCC and the Treasurer. It's kind of combined procedure.
That's right. So the ACCC is a portfolio of the Department of the Treasury in terms of where that sits overall within the Australian government. And the Foreign Investment Review Board is a non-statutory body that sits within the Department of Treasury as well. So it is all about ensuring Australia's economic development and that investment flows can come in. With the idea that most transactions, again, 99% of transactions are going to get through the system, but it is something to ensure the confidence of the system that the Australian government wants to screen and in most cases permit.
I have a question. How long it takes for obtaining the clearance from the authority?
A very, very good question, Gabriel. So most of the time, in a normal environment, I would say that you get through it in about sort of 10 to 12 weeks if there was nothing particularly controversial about a transaction. But that time frame is affected by many, many factors. And in practice, it takes as long as it takes. So at the moment, that time frame is affected by the federal election that is upcoming. During COVID, that timeframe was affected by the increased workload because of that $0 threshold across all investments. Because the decision maker is the Treasurer of Australia, when the annual budget is handed down every year, there are other duties the Treasurer has that limits his capacity to look at these approvals as well. And so things sort of wax and wane throughout the year because of those external factors as well.
Okay, thank you.
If there's no other question, thank you, Melissa, for this wonderful presentation. And then we can welcome for our next presenter, Rachel Lee from Zhonglun Law Firm, to give us a presentation about the FDI regime in China. Thank you, Melissa.
Okay, thank you, Melissa, and thank you, staff, for the introduction. Hi, this is Rachel Lee from Zhonglun. I'm in Beijing now. And sorry that I did not prepare some slides for the introduction of China FDI regime. So I'll try to just make myself clear and to share some of our experiences and observations of China FDI regime with you. So if there's any question, you can just jump in and raise questions, during the process. Okay, so China's FDR review regime compared to like Australia is, I would say, is quite young. So actually, for the first time, China's FDR review system was mentioned in China law is in 2006. It's mentioned in one of the old, so-called old China's foreign investment rules that if any foreign investment in China might impact the national security, then it should be subject to some security review. And under the old rules, these detailed implementing regulations about this national security review was promulgated in 2011. And the relevant authorities, namely the NDRC, the National Development and Reform Committee, and MOFCOM are quite active in 2011 to 2013. And we know that several cases were submitted and reviewed by them, and at least one of them were prohibited. But then, I just mentioned the old rules because maybe some of you may know that in the past like 10 years, China's legislators and government, they want to do some reform of our entire foreign investment regulation system. So after 2013, the old national security review mechanism actually became quite dormant in practice, and we haven't heard any cases in several years until 2019. Maybe you know that in that year, the new foreign investment law was formally promulgated by China's legislators. And then in that law, it is restated that this national security review system or foreign investment security review system, we call it FISA, but for convenience, I will still call it like FDI review. It's a very important part of this new foreign investment law. And then in late 2020, NDRC and MOFCOM, the very two important enforcement agencies, promulgated the latest and the current foreign investment security review rules in China. It took effect in early 2021. So you see, it's very young. It's this new FDI system of China is very young, and it has only took effect for about like more than 1 year, this time period. But this review system actually is a new and an upgraded system compared to the past. So I would like to take this opportunity to introduce some of the highlights of this new system to you. So the first highlight is that actually the scope of transactions that to be captured by this new system is quite broad. So in our old system, only those M&A transactions, the acquisition of assets or acquisition of shares, this type of transaction would be captured. But in this new system, all the type of foreign investment transactions might be captured. No matter it is merger and acquisition, or it's just a greenfield transaction, like you just establishment of a new like a JV or a new like a WFI, or for investment in other forms like contractual control. I mean, no matter what type of the form, as long as the essence is a foreign investor want to invest some of China's like industry, then it might be captured. And I would like to note here that maybe some of you know that there's a quite special form of foreign investment in China called VIE structure, variable invest interest entity. And this type of structure actually is a contractual control structure. I mean, you know that because in some like heavily regulated industry in China, like internet, there are lots of industrial permit requirements, and some of the foreign investment in the past 30 years, they just use this form to bypass some of those requirements. And this structure actually has been heavily disputed in practice. And in many areas like antitrust, there have been like several years, I mean dozens of years, that the authority keeps like silent on whether it should be counted as foreign investment or not. But now, under this new rule, this new FDI rule, it is quite clear that any investment in VIE form would also be captured by this FDI form. So this is the first highlight that any type, any form of foreign investment might be captured by this review form. The second highlight is the threshold about this FDI review. So under this new rule, there are two scenarios where a transaction might be like captured. I mean, if they meet any of the scenario. And the first scenario is a national defense related scenario. So under this scenario, if any investment is made in military industry or military accessory industries, or if any investment itself is not in a military industry, but the location of this investment, the facility is adjacent or nearby to some military bases or the borders, then regardless of the equity share or control status of this transaction, this type of transaction will be captured by this FDI review requirement. So that means that if your industry is military related, or if the location is very sensitive, that even if the foreign investor only invests in 1% of the project, then the FDI review will still be triggered. The second scenario is non-military related scenario. So if the foreign investment, I mean, most occasions, they are investing in some industries which are not related to military or national defense. But if this industry is very important to begin to have some like bearing in China's national security, then, and also if the foreign investor is going to gain some effective control in the target company or target assets, or in like a greenfield investment, then this type of non-military related transaction may also trigger FDI review. So by the industries that I just mentioned, which is not military related, but still have bearing on the China's national security, there are some like examples made in the relevant rules. It's listed like agricultural, energy and resource, infrastructure, equipment, manufacturing, transportation, cultural, financial service, internet technology, and other important technologies, and so on. And very obviously that it is not an exhausted list. So in the practice, we have seen that actually the enforcement agencies, they have quite broad discretion in determining what industry and whether this transaction, I mean by industry, have a bearing on China's national security. At least the very first case after this new rule of China's FDI review took effect, actually it is in retail industry. See, so that could be some challenge to the foreign investors because, you know, in China, many like parameters of this threshold is not that clear, right? For the industries, even if your industry like retail is not like named in the rules, but it might be deemed by the authorities to have some bearing on the the national security. And also on the other keyword, right? Because most of these investment are in non-military related industries. So according to the rule, the foreign investor has to have some like effective control in this transaction. But what is effective control? So unlike Australia, that you have a very clear threshold like 10% or 20%, but in China, no. We only have a narrative description of effective control. So in practice, the enforcement agencies also have large discretion in determining what constitutes effective control. At least in this case that I just mentioned, the very first case, that case, this foreign retailer would like to increase its shares from in another like domestic Chinese retailer from like about like 24% to like 35%. But combined with some like government corporate governance like clauses, the authorities just deems that after this transaction, although only have like 35% of the shares, but you would gain effective control. So that is an example. So what would constitute effective control and what would constitute some bearing on national security? The China's authorities would have large discretion. So the third highlight of this review system is that there are different ways of the China's new FDI review procedure be initiated. So in most occasions, the foreign investors, they would do some self-review and voluntarily consult with the authorities, or to just go ahead to make a filing if they feel that their like transaction fall under this scope. But also, in many cases, we have seen in many cases that the foreign investors, if they, whether they know or not, they might be captured by this review form when they carry out other regulatory procedures in China for the transaction. They may be required by the authorities to do the FDI review procedure. For example, I have just mentioned this very first case. This is a retail case. In that case, actually, the parties to that transaction, they did not realize that their case may be captured by FDI review. But when they conduct the antitrust review procedure with China's SAMR told them that, well, we have reviewed your case. It's clear from antitrust like side, but we just note that this case has some like bearing on the national security, so you should go ahead and file with NDRC for the FDI review. This is quite interesting, and recently we have another case. In this case, due to this complicated deal structure, the parties need to carry out some overseas investment like approval procedure, the ODI approval procedure with China's authorities. And during that procedure, they were required by the authority, actually it's also in the RC, that this case triggered national security review, FDI review. So you need to go ahead and file with the FDI like office, like always like, coordinated by NDRC and for this FDI review. So this is quite interesting. So I would say that now this China's FDI review form is becoming very important, and we call that the new form, a new norm of foreign investment in China. So the foreign investor would like take care of this, especially if your transaction would counter any like other regulatory approval procedures in China. The next highlight is that the impact of this FDI procedure to the foreign investment in China. So I would say it is quite clear that from the perspective of China's regulators or legislators, they do not want this FDI review form to be a barrier of the foreign investment in China. Actually, just in the last week, our Deputy Prime Minister, they just stated to the media of like all the countries that the open gate of China will not close. They hope this FDI review mechanism becomes some kind of like new form, a new norm. It's like antitrust reviews. It's kind of like some routine review system of foreign investment in China, and as long as I know that because I mean those FDI approval decisions, they would not be published due to its nature. It's confidential, but we know that most of cases reviewed by these FDI regulators actually are cleared. Only small portion of them are like prohibited, or some like conditions are imposed. But it's just 1 year or something. So the cases are not that many.
Rachel,
yes.
I'm sorry. We have almost like only 10 minutes left, and we still have another speaker.
Yeah, sorry.
Yeah.
I wrap up very, very quickly. What I want to say is that compared to the substantive consequence, I would say that the timeline, the impact to the timeline of the transaction would be more substantial and challenging to the foreign investors, because as far as we observed, this FDI procedure, maybe because this is new to the regulators, they are not that familiar, and they become very, very, very conscious. So at this point, the time required for this review actually is a bit long. I would say several months or even over 1 year. So that's something that the foreign investor will need to to consider before they start the transaction. So I think that's basically pretty much things that I want to share. So I think I will just stop here to see whether there's any question.
Any question? Yeah, if not, then yeah, thank you, Rachel. Then we move to our third and last speaker, Mark Case, from the Canadian member of WLG, Davis. Thank you, Mark.
Thank you, Scott. Thank you very much, Scott. Good evening, good morning, good afternoon to everybody. I sort of fall in between Melissa and Rachel. I did prepare slides, but I'm not going to go through them now. You can see them later on, I guess, when the materials are posted.
Given we started late, I mean, Mark, you still have enough time for you to continue. No. Yeah,
I'm not complaining at all. It's plenty of time for me. I think in the context of what I'll be speaking about briefly, you'll hear some common topics. For example, especially on the national security review side of our investment FDI review in Canada, very broad discretion, no real solid definition of what is entailed by national security, and potentially lengthy timelines. So all of that is quite common, it sounds to me, across the board. But just to summarize very briefly, the situation in Canada, our foreign investment legislation actually goes back to 1973. So we're also among the early, I guess, pioneers, so to speak, in this area. That legislation was radically reformed in 1986, and it's the 1986 legislation that forms the current basis of what we're dealing with. And initially, between 1986 and 2009, the test that was applied, the crux of foreign investment review in Canada, involved whether or not a proposed acquisition of control, and it was limited to only acquisitions of control, not minority investments, would be of net benefit to Canada. So again, somewhat similar to what you have under FIRB, minus the national security element at that point. But the government would look at assuming that the transactions crossed the relevant thresholds and involved an acquisition control, the government would look at factors like impact of the investment on the business, impact of the investment on the Canadian economy, impact on competition as well, although, as in the other jurisdictions, that was largely outsourced to the Competition Bureau to deal with, impact and consistency with Canadian government policy. The main thing to know about the net benefit review process is that I think with at least it's divided between cultural and non-cultural businesses. Most of the time we're dealing with non-cultural businesses, cultural businesses being things like books, magazines, films, and so on, which has its own particular world. But certainly on the non-cultural business side, which makes up the bulk of the investments that were subject to the process and subject to review, there was basically between 1986 and say the early 2000s, and even since then, only 2 transactions that were ever turned down. So it was not a case of many deals being denied on that basis. The vast majority, the vast bulk of transactions were cleared on the basis of commitments or undertakings that the investor would have to provide to show that it was going to basically pony up and provide benefits to the business, whether in terms of monetary investments or committing not to fire employees in Canada, committing to retain Canadian management, committing to retaining headquarters in Canada, and so on. So it was and still is the type of process where you knew as an investor more or less what was involved going in. You would go through the process and then would emerge more or less with everything intact, and at least emerge with the transaction that you wanted, and very little risk of a transaction being denied. In 2009, the Investment Canada Act was amended to introduce a national security component. And at that time as well, there was a shift in philosophy, a shift in approach. The Conservative government at the time, which wanted to be viewed as being open to investment, but tough on national security, arranged the new thresholds so that very few and progressively fewer transactions would be subject to this net benefit review process. But the national security process that was introduced was potentially extremely broad in scope. There were no monetary thresholds, no requirements for there to be an acquisition control, so minority investments could be caught, and no definition of what national security was. So it could be, the classic things that we would think of: national defense, espionage, things of that nature, but no ceiling, at least in terms of what could actually be caught. And what we've seen in the last, I guess now it's about 13 years or so since the national security review process was introduced, is that the number of net benefit reviews has declined precipitously, to the point that for the most recent year, which covers the COVID period, there were only 3 net benefit reviews in the entire year. Now, part of that is obviously due to the fact that there were fewer investments because of COVID, but nonetheless, even the year before, there were 9 of these reviews compared to over 20 or so in prior years. So there has been a precipitous decline in the number of reviews and the importance of net benefit reviews. Conversely, we've seen the number of national security reviews, or at least the number of transactions that are implicated by national security reviews, or the national security review process, climb to unparalleled heights, at least in our terms. So for the last year, for example, when there were only 3 net benefit reviews, there were 24 transactions that were caught by the national security review process, about half of which went to a formal national security review. And I won't get into all the details, but there's basically a screening process. So at least 24 of transactions went through an extended screening process, and about half of them were ultimately referred to a full national security review. And of those, about, I think, half at least resulted in sanctions, whether being prohibited or in investments being withdrawn. And we're seeing more and more transactions that are caught by the national security review process being withdrawn by the investors. So that's effectively, effectively a blockage. So it's in terms of the possibility, the eventuality of remedies of some sort of sanction, much more of a bite on the national security side than there ever has been and ever will be, I think, on the net benefit side. One other point that I'd mention now, and this goes to something a bit that Melissa referred to in terms of the importance of the character of the investor. On the national security side, at least, character of the investor has largely been defined consistent with the country of origin of the investor. And I guess with apologies to Rachel and others, the inescapable fact of Canadian national security review is that most of the transactions that have been reviewed and most of the transactions that have been blocked have involved Chinese investors. Certainly in the last year, of the 11 reviews that I mentioned that took place, 7 of those involved Chinese investors. Now, to put all this in perspective, the number of transactions that are reviewed, that are subject to national security review, are very small. The number of Chinese investments, for example, that are undergo this type of review and that are blocked are also very small, but they tend to attract a fair bit of controversy. And in the last few months alone, since the beginning of 2022, we've seen a number of instances in which, at least one instance in which a Chinese investment was cleared that generated all kinds of controversy, public controversy, parliamentary hearings, and now a recommendation that's come out of the Canadian Parliament that all such investments by any unfriendly nation, basically, or actually they call it authoritarian nation, should be reviewed automatically, subject to national security review. So there's clearly a sense here that the national security review regime should be enforced and applied even more vigorously than it has been. And what we've also seen in the wake of the Russian invasion of Ukraine is, again, a specific policy that was issued in relation to investments by Russians in Canada, and enhanced scrutiny applied, enhanced rules applied to the effect that to the extent that any of these transactions are subject to net benefit review, they will only be cleared in extraordinary circumstances, and that any investment that involves anyone with any connection to the Russian state, the Russian government, will automatically go to be subject to a full national security review. So in terms of trends, basic trends that we've seen on the net benefit review side, that has basically gone the way of the dodo, or is clearly heading that way. National security review, more pronounced, more controversial, and the trend, at least sort of the populist trend, is to advocate for even stricter application of the rules and the broadening of the potential application of the rules. And we'll see if that is actually transformed into actual legislation in the next year or so. So I think that's, I'll stop there and we'll see if there's any questions.
I've got a question mark. Thank you for that. Very, very helpful context. I hadn't quite appreciated the breadth of the national security reviews, but not surprising in terms of what you said around the policy. One of the things about Australia's national security rules is that you can have a foreign company that simply does business with Australia. So, you know, it might do so under a foreign contract, but it delivers a service into Australia and doesn't have a physical presence here, but that might be enough for something to be caught. So many offshore transactions offshore Australia, can still be caught up in the foreign investment rules here. Is that sort of same breadth applicable in Canada?
No, Melissa, I think, thank you for mentioning that, because there's one part of the regime that I didn't get into, is that the national security review regime also applies to the establishment of a Canadian business. But I think you have to, at least here, have taken that step. Simply having business dealings, contractual dealings, contractual arrangements of some sort, wouldn't trip even the fairly broad scope of the national security review process. But there has been, interestingly enough, and I'll close with this anecdote at least, one recent transaction where the Canadian government ordered again, unfortunately, a Chinese company to basically shut down a business that it had established 5 years ago because the government learned about it and eventually decided that it was contrary to the Canadian national interest and ordered it unwound. So to that extent, there's also a fairly long tail that it has to take action.
What kind of business was it?
Telecom. Telecom, so it's very sensitive.
I do not have questions, but I have two remarks. The first remark is it's interesting to see how developed your regimes are with these foreign direct investment controls, and that not only national security issues take place in Germany. We have merger controls since more than 50 or 60 years, since 1973, and a lot of investigations and tough discussions on, in my view, unimportant things, but nobody thought a lot about national security, and only when more Chinese companies bought German ones, this started, and only during last year, foreign direct investment control became really tougher, and we even had a case which was not cleared, so turned down. This was the Siltronic case, where the Chinese authorities cleared it 10 days before the end of the deadline of the German authority, cleared it under conditions, and then the German authority didn't have time enough to investigate the consequences of the conditions on German national security and simply didn't act, and there was a long stop date in the agreement, and then the transaction was off. And when we looked at national security issues, a lot of people always thought about China, never thought about any other country. And now it was only yesterday that people realized that Gazprom, via Gazprom Germania, owns really substantial infrastructure of the gas distribution in Germany, and nobody really thought about this. And I think this will have a strong impact on such national security review in the future. So interesting times ahead, I think.
Yeah, well, I think in that respect, Harold, national, at least from the Canadian experience, national security especially, it's very political. So when politics change, when foreign affairs change, the perspective changes as well.
Yeah, I agree. Actually, 20 years ago when I started my legal career, in China, we didn't have merger review. We didn't have national security. We heard of something called CVS, but China never really experienced any difficulty at the time. Of course, it's also because China had a very few investments at that time in either of Europe or the US. And nowadays, I mean, with the trend of deglobalization and also the tensions between especially China and other major economies, we feel more and more this kind of pressures from both directions. Mm-hmm. So this will be, I think it's very interesting and very useful. Actually, today we have brought the FDI issue into our conversation. Again, it seems like because of many reasons, especially of the spring conference of ABA's antitrust section. I don't blame them for that, but because of that, we don't have enough attendees for today. But I'm sure that today's topic is very interesting to our member firms and the lawyers, and they will come to definitely come to look at the records. Thank you, everyone.
If I would start my career, if I would start my legal career now, I would be much more interested in foreign direct investment control than in merger control. This is really very interesting, very interesting. I left this topic to my other competition partners. Big mistake. And the interest of the subject is completely, what is the English word, in contradiction to the number of participants. I'm very sorry that we have such a low attendance. I never thought this would be possible. Hannah will distribute the materials, and I hope that people will then find more interest in the topic. It is really, I think people didn't simply realize how important the topic is and how important it will become. So also from my side, thank you very much for your very insightful talks.
Yeah, I joined our, thanking you.
Gabriel.
See, I have a quick question to Mark. In the case you mentioned, there has been any judicial challenge for such decision or not?
So there have been, the one that I mentioned where the government stepped in after 5 years is now currently under review.
Okay.
Although the company tried to get an injunction to prevent the enforcement of the order against them, because what they said is the order, I think, obliged them to close down their operations in Canada in January, and of course they were only coming to the court hearing in May. But interestingly enough, the injunction was denied, so they've had to shut down the company. And there was one other case, again similar to that one, where a company had been ordered to divest an operation that it had established. They brought a challenge, and the Canadian government at the time backed down and said, okay, we'll rescind our order that you have to basically divest the business, and instead you'll just have to comply with these specific commitments or undertakings. That one was, interestingly enough, came at a shift, again, to get back to my point about politics, came to a shift in governments here. The prior Conservative government had been very, as I said, pro-national security. The new Liberal government that came in, as many new governments want to do, wanted to change a new leaf, wanted to be even more inviting to foreign investment from China. Again, it's a sort of a bête noire in Canada. And so in that case, decided to rescind the decision to force a divestiture in favor of these commitments to allow the company to stay. But we've seen even in the few years since then a bit of a schizophrenic attitude of the Canadian government currently towards how to deal with national security. And in part, that's because of pressure brought by the United States and others to be tougher. But I don't think the current government is not really inclined to be that tough. And there's this back and forth that they go through.
So Scott may not be able to close the session, so I will. Now Scott.
No, thank you, Harry. Actually, I want to, special thanks to you for you to stay so late with us.
It was very interesting.
It is, for all of us.
I could not have slept if I would not have followed this session. No, it's really very interesting. It's not just.
So thank you, everyone. If there's, and if you have any additional questions, you can always email to the speakers. You can find their contact information from our website. And again, thank you, everyone, for the great presentations. We learned a lot. I think we will, I need to discuss this with Harold, but I personally think this is a very good topic that we should spend more time to explore from speaking for all our the team members and probably for the entire members.
Good, thank you.